That's a good point. I'm going to call the Raritan Township Board of Adjustment, January 6, 2022 reorganizational and regular meeting to order by reading the notice requirements of the Open Public Meetings Act. And those requirements have been satisfied. Actually, Jackie, can you hear me?
Yes, I can. Yes.
Those requirements have been satisfied by the placing of a notice of this meeting on the bulletin board at the municipal building, filing same with the township clerk, and transmitting same to the Hunterdon County Democrat, the Courier News, the Star Ledger, and the Trenton Times. At this point, I'm going to ask, we have a holdover secretary and a holdover attorney. So I'm going to ask our holdover secretary to call the roll.
Miss Cynthia Schaefer.
Here.
Mr. Roger Aarons.
Here.
Mr. Kevin Cool.
Here.
Mr. Steve Farcio.
Here.
Mr. Randy Block.
Here.
Mr. Jim Ferrero.
Here.
Mr. Brad Perry.
Here.
Mr. Bill Cummins asked to be excused tonight.
Okay. Other personnel, I am the board attorney. I am here. Tony Hajar, township engineer and board engineering expert. That's correct. Are you here? Yes. Jessica Caldwell is excused. John M. Thomas, the landscape architect, is excused. Charles Heck, the radio frequency engineer, is excused. Jay Troutman, the traffic engineer, is excused. I don't see, interesting, Jeff Vaccarella, but he's here, and he is the township assistant planner. And then Jackie Clapp, our board stenographer.
Yes.
She's here.
I'm sorry, John. I never know if we do that at reorg or not.
That's all right. So until the board elects a chair, I'm going to run the meeting. So I want to know if there are any comments by board members. Seeing none, any announcements?
No.
Okay, so now it is time to elect the officers. So I'm going to ask if someone could make a motion to elect someone as the chairman.
I'll make a motion to nominate Roger Aarons as the chairman.
And is there a second?
A second.
So for Jackie, we have to say who made the motions and who seconded because she's on Zoom. So Cynthia Schaefer made the motion and Randy Block seconded it. And I'm going to ask the holdover board secretary at this point to call a roll on the chair.
Miss Cynthia Schaefer.
Yes.
Mr. Roger Aarons.
Yes.
Mr. Kevin Cool.
Yes.
Mr. Randy Block.
Yes.
Mr. Steve Farcio.
Yes.
Mr. Jim Ferrero.
Yes.
Mr. Brad Perry.
Yes.
Okay, first of all, congratulations, Roger. And it's your baby for the year now.
Don't we have to now elect the vice chair?
Now it's up to you.
Do you want to?
Do we have any nominations from the floor for a vice chair?
I nominate Kevin. So Jackie, did you get that? Randy Block nominated Kevin Cool. Now, before you do a motion, why don't you ask if there are any other nominations?
Any other nominations from the floor?
And all members on Zoom, you're also part of the floor.
And I assume we need a second if there are no others.
Then you'll make a motion to elect him with a
Correct.
second.
I'll second that. Steve Farcio.
And I guess Roger Aarons made the motion.
Yes, correct.
I think I have Randy.
Randy, it was a nomination.
Right. Randy made the
Okay, so the
nomination.
motion was Roger.
And Steve Farcio was the second.
Miss Cynthia Schaefer.
Okay.
Yes.
Roll.
Mr. Roger Aarons.
Yes.
Mr. Kevin Cool.
Yes.
Mr. Randy Block.
Yes.
Mr. Steve Farcio.
Yes.
Mr. Jim Ferrero.
Yes.
Mr. Brad Perry.
Yes. Now, do we have any nominations for a vice chair pro tem?
And just for the board's information, again, if anyone forgets, it's a good practice that I've suggested. It's in the rules that the board elect a vice chair pro temp now in the beginning of the year. If you ever get into a situation when either the chair and vice chair are absent, or one is absent and one is recused, or whatever, you don't have to
I can't.
scramble around. You have someone on the bench ready to step
I,
up.
I don't want to move.
Roger, this is Steve Farcia. I would nominate Cynthia.
I second that.
Someone want to ask her first if she's willing to accept,
Are
and
you
if she
willing
is,
to
someone make a
accept?
motion to elect her.
Yes.
I move that we elect Cynthia Schaefer as the vice chair pro temp. Roll call.
Can I have a second?
Second. Yes, I will second it.
Who made the motion now?
Steve.
I have
Steve.
Roger made them. I think Steve made the nomination.
Right,
Right.
Steve made the nomination. I think you made the motion.
Yep.
I second it.
Kevin
Fine.
Cool
Kevin
just seconded
seconded.
it.
Okay. Miss Cynthia Schaefer,
Yes.
Mr. Roger Aaron's.
Yes.
Mr. Kevin Cool,
Yes.
Mr. Randy Block,
Yes.
Mr. Steve Farcio,
Yes.
Mr. Jim Ferrero,
Yeah, yes.
and Mr. Brad Perry.
Yes.
Okay. Now we have a number of housekeeping matters to deal with tonight. This is a reorganization meeting. So for those of you that are sitting in the audience, we have to ask your patience because we must go through this. We must reappoint a number of people, and you'll just have to be patient with us while we do this. All right, our first appointment is for the attorney, board attorney. We have a resolution in front of us. It's called Raritan Township Board of Adjustment Resolution Appointing and Retaining Board Attorney for 2022. Whereas there exists a need for professional legal services for the board for the year, and the municipal land use law NJSA 4055D-71B provides that the board may employ an attorney. Whereas the board determined that Jonathan E. Drill Esquire should be appointed and retained as attorney for the board for the year. Now therefore be it resolved by the Raritan Township Board of Adjustment on January 6th, 2022 as follows. 1, Jonathan E. Drill Esquire is hereby appointed and retained to represent the board in all legal matters and to act as its attorney for the year 2022. 2, the board attorney, as well as other attorneys from Stickle, Koenig, Sullivan, and Drill, as designated by the board, shall provide such additional legal services to the board as the board directs. 3, the board attorney shall be compensated in accordance with the terms of a professional service agreement to be entered into between him and the township. 4, a notice of this resolution shall be published in an official newspaper of the township and in accordance with local public contracts law.
You're asking for a motion for
I-
someone to adopt that resolution?
Yes.
So
I'm
John, I
asking-
checked back from last year. Last year, we did all the appointments and then we did one motion and second for the appointments. I don't know if you want to do it the same way.
Okay.
Do it
we'd
that
like-
way. That would save a lot of reading.
Yes, I would like to do that.
Okay.
Second resolution appointing board planning expert for 2022. Whereas there exists a need for professional planning services for the board for the year, and the municipal land use law NJSA 4055D-71B provides that the board may employ such experts and staff as it shall deem necessary. Whereas the board determined that Jessica Caldwell, PP, AICP, should be appointed as the board planning expert for the year. Now therefore be it resolved by the Raritan Township Board of Adjustment on January 6, 2022 as follows. 1, Jessica Caldwell, PP, AICP, is hereby appointed board planning expert for the year 2022. 2, the board planning expert shall be compensated in accordance with the agreements to be made between them and the township. 3, a notice of this resolution shall be published in an official newspaper of the township and in accordance with the local public contracts law. Three, this is the third resolution, resolution appointing board engineering expert for 2022. Whereas there exists a need for professional engineering services for the board for the year, and the municipal land use law, NJSA 4055D-71B, provides that the board may employ such experts and staff as it shall deem necessary. Whereas the board determined that Antoine Hajar, PE, the township engineer, should be appointed as board engineering expert for the year. Now therefore be it resolved by the Raritan Township Board of Adjustment on January 6, 2022 as follows. 1, Antoine Hajar, PE, township engineer, is hereby appointed board engineering expert for the year 2022. 2, the board engineering expert shall be compensated in accordance with agreements to be made between him and the township. 3, the notice of this resolution shall be published in an official newspaper of the township and in accordance with the local public contracts law. This is the fourth resolution. Resolution appointing board traffic expert for 2022. Whereas there exists a need for professional traffic engineering services for the board for the year, and the municipal land use law, NJSA 4055D-71B, provides that the board may employ such experts and staff as it shall deem necessary. Whereas the board determined that J.S. Troutman Jr., PE, should be appointed as board traffic expert for the year. Now therefore be it resolved by the Raritan Township Board of Adjustment on January 6, 2022 as follows. 1, J.S. Troutman Jr., PE, is hereby appointed board traffic expert for the year 2022. 2, the board traffic expert shall be compensated in accordance with arrangements to be made between him and the township. 3, a notice of this resolution shall be published in an official newspaper of the township and in accordance with the local public contract law. This is the fifth resolution. Resolution appointing board landscape architect expert for 2022. Whereas there exists a need for professional landscape architectural services for the board for the year, and the municipal land use law, NJSA 4055D-71B, provides that the board may employ such experts and staff as it shall deem necessary. Whereas the board determined that John Morgan Thomas, LLA, ASLA, should be appointed as board landscape architectural expert for the year. Now therefore be it resolved by the Raritan Township Board of Adjustment on January 6, 2022 as follows. 1, John Morgan Thomas, LLA, ASLA, is hereby appointed board landscape architectural expert for the year 2022. 2, the board landscape architectural expert shall be compensated in accordance with arrangements to be made between him and the township. 3, a notice of this resolution shall be published in an official newspaper of the township and in accordance with local public contract law. The sixth resolution. Resolution appointing board radio frequency expert for 2022. Whereas there exists a need for services of a radio frequency expert and wireless telecommunications expert for the board for the year, and the municipal land use law, NJSA 4055D-71B, provides that the board may employ such experts and staff as it shall deem necessary. Whereas the board determined that Charles Hecht, PE, should be appointed as board radio frequency and wireless telecommunications expert for the year. Now therefore be it resolved by the Raritan Township Board of Adjustment on January 6, 2022 as follows. 1, Charles Hecht, PE, is hereby appointed board radio frequency and wireless telecommunications expert for the year 2022. 2, the board radio frequency and wireless telecommunications expert shall be compensated in accordance with arrangements to be made between him and the township. 3, a notice of this resolution shall be published in an official newspaper of the township and in accordance with local public contracts law. The 7th resolution, resolution appointing board secretary and assistant secretary for 2022. Whereas there exists a need for secretarial services for the board and the municipal land use law, NJSA 4055D-69 and 71B provides that the board may elect a secretary who need not be a member of the board and employ such staff as it shall deem necessary. Whereas the board determined that Amy Fleming should be appointed as secretary for the board and that Antoine Hajar should be appointed as assistant secretary for the board. Now therefore be it resolved by the Raritan Township Board of Adjustment on January 6, 2022 as follows. Amy Fleming is hereby appointed as secretary to the board for the year 2022 for the purpose of providing secretarial services to the board during all board meetings, which services include but are not limited to providing for the verbatim recording of all public portions of board meetings by audio taping means and signing true copies of all resolutions adopted by the board and all site plans and subdivision plans approved by the board once all conditions of approval have been satisfied. Antoine Hajar is hereby appointed as Assistant Secretary of the board for the purpose of performing the functions of the board secretary in the event of the absence or unavailability of the board secretary. 4, actually, that should be number 3. The board secretary and board assistant secretary shall be compensated in accordance with arrangements to be made between them and the township. 4, a notice of this resolution shall be published in an official newspaper of the township and in accordance with the local public contracts law. Resolution 8, resolution appointing board stenographer for 2022. Whereas there exists a need for stenographic services for the board for the year and the municipal land use law, NJSA 4055D-71B and 10F provides that the board may employ such staff as it shall deem necessary and that the board shall furnish a transcript or duplicate recording in lieu thereof of its proceedings to any interested party at his expense. Whereas the board determined that Jacqueline Clapp should be appointed as board stenographer for the year, now therefore be it resolved by the Raritan Township Board of Adjustment on January 6, 2022 as follows. 1, Jacqueline Clapp is hereby appointed board stenographer for the year 2022 for the purpose of providing for the verbatim recording of all public portions of board meetings by stenographic means, as well as providing transcripts of such proceedings to any interested party at such interested party's expense. 2, the board stenographer shall be compensated for her appearance to make the verbatim recording of all public portions of board meetings by stenographic means in accordance with arrangements to be made between her and the township. The board stenographer shall also be responsible for preparing and distributing meeting minutes of all portions of all board meetings. 3, the board stenographer shall furnish transcripts of the above-mentioned proceedings to any interested party at said party's expense and in accordance with financial arrangements to be made between her and the interested party or parties, as well as in accordance with law. 4, a notice of this resolution shall be published in an official newspaper of the township and in accordance with local public contracts law. The next resolution is the resolution appointing board conflict engineering expert for 2022. Whereas there exists a need for professional engineering services for the board for the year and the municipal land use law, NJSA 4055D-71B provides that the board may employ such experts and staff as it shall deem necessary. Whereas the board has determined that Antoine Hajar, PE, should be appointed as board engineering expert for the year, whereas the board has determined that Larry Plevier, excuse me, PE should be appointed as board conflict engineering expert for the year. Now therefore be it resolved by the Raritan Township Board of Adjustment on January 6, 2022 as follows. Larry Plevelier, PE of Mott McDonald, is hereby appointed board conflict engineering expert for the year 2022 and may be called upon to serve the board by the board chairperson when the board engineering expert has a conflict of interest or an appearance of a conflict of interest. 2, the board through its chair may designate other professional engineers from the firm of Mott McDonald to provide engineering services at any of its various meetings and/or to provide such additional professional services as directed by the board when the board engineering expert has a conflict of interest or an appearance of a conflict of interest. 3, the within appointment is subject to entry into a professional services contract between the conflict engineering expert and the board. 4, a copy of this resolution shall be published in an official newspaper of the township and in accordance with the local public contracts law.
Hold on 1 second. Just want to read from the. I think we forgot a sentence in there. Not that you missed it, it's not in there. No, we have it. We have it. It's just that there's no reference to compensation, but we do say that within appointment is subject to entry into a professional services contract.
Right.
Why don't we just leave it alone? That'll cover it.
Okay. The next resolution is a resolution appointing board geotechnical and structural engineering experts for 2022. Whereas there exists a need for professional geotechnical and structural engineering services for the board for the year, and the municipal land use law, NJSA 4055D-71B, provides that the board may employ such experts and staff as it shall deem necessary. Whereas the board determined that Gerald Jerry Adelson, PE, and Richard Rick Adelson, PE, of Frank H. Lear Associates Consulting Engineers should be employed and appointed as board geotechnical and structural engineering experts for the year. Now therefore be it resolved by the Raritan Township Board of Adjustment on January 6, 2022 as follows. 1, Gerald Jerry Adelson, PE, and Richard Rick Adelson, PE, of Frank H. Lear Associates Consulting Engineers are hereby appointed board geotechnical and structural engineering experts for the year 2022. 2, these experts shall be compensated in accordance with arrangements to be made between them and the township. 3, a notice of this resolution shall be published in an official newspaper of the township and in accordance with the local public contract law. And this is the last resolution appointing board conflict traffic expert. Whereas there exists a need for professional traffic engineering services for the board for the year, and the municipal land use law, NJSA 4055D-71B, provides that the board may employ such experts and staff as it shall deem necessary. Whereas the board has determined that Walter M. Lublanecki, PE, should be appointed as board conflict traffic expert for the year. Now therefore be it resolved by the Raritan Township Board of Adjustment on January 6, 2022 as follows. Walter M. Lublanecki, PE, of Lublanecki Engineering, Inc., is hereby appointed board conflict traffic expert for the year 2022 and may be called upon to serve the board by the board chairman when the board traffic expert has a conflict of interest or an appearance of a conflict of interest. 2, the board through its chairperson may designate other professional traffic experts from the firm of Lublanecki Engineering, Inc., to provide traffic engineering services at any of its various meetings and/or to provide such additional professional services as directed by the board when the board traffic expert has a conflict of interest or an appearance of a conflict of interest. 3, the within appointment is subject to entry into a professional services contract between the conflict traffic expert and the board. 4, a copy of this resolution shall be published in an official newspaper of the township and in accordance with the local public contracts law.
I make a motion to approve all the resolutions that have been,
Can I have a second?
I second
a second, Jim Ferraro.
I
Okay,
think I heard Randy, right?
it was Randy.
Yeah, I heard Randy first on the second.
Amy, could I have a roll call, please?
Ms. Cynthia Schaefer,
yes,
Chair Mr. Roger Aaron's.
Yes.
Mr. Kevin Cool,
Yes.
Mr. Randy Block,
Yes.
Mr. Steve Farcio,
yes,
Mr. Jim Ferraro,
Yes,
Mr. Brad Perry.
Yes. Okay, moving on to minutes. We have 2 sets of minutes for tonight. We have the minutes from December 2nd, 2021. Has everyone had a chance to read the minutes, and could I have a motion to accept those minutes?
I'll make a motion to approve the meeting minutes.
Second,
Is that Kevin?
Yeah,
Kevin or Roger? Roger
yeah.
did that.
Okay.
Let's say it so Jackie gets it. Who's the second?
I have Roger.
Okay,
I have Cynthia made the motion, then Roger. Ms. Cynthia Schaefer.
Yes,
Mr. Roger Aaron's.
Yes.
Mr. Kevin Cool,
Yes.
Mr. Randy Block,
Yes.
Mr. Jim Ferraro,
yes,
Mr. Brad Perry.
Yes. Okay, we also have minutes for December 16, 2021. Has everyone had a chance to read the minutes? Any corrections? Could I have a motion, please?
make a
So-
motion to approve the December 16th meeting minutes.
Thank you, Cynthia. Second, Randy Block.
Yes.
Roll call, please.
Ms. Cynthia Schaefer.
Yes,
Mr. Roger Aaron's.
Yes.
Mr. Kevin Cool,
Yes.
Mr. Randy Block,
Yes.
Mr. Steve Farcio,
yes,
and Mr. Jim Ferraro.
yes,
Okay, John, we are up to the resolution establishing meeting schedule for 2022. Do we need to read that in its entirety?
believe it or not, normally I would say no, but this year, Amy, do we have the language in here or not?
yes,
Yes, it's number 3, John.
Yeah, I think you should. just
Okay.
For the record, for the public.
Fine. Okay.
Yep.
Resolution establishing meeting schedule for 2022. Whereas the municipal land use law NJSA 4055D-9 provides that the board shall schedule regular meetings not less than once per month. Whereas the Open Public Meetings Act NJSA 10:4-18 provides that at least once each year within 7 days following the board's annual reorganization meeting, or if there be no such reorganization meeting, then by January 10th of that year, the board shall post and mail to the township official newspaper and a newspaper of general circulation notice of the dates for its regular scheduled meetings for the year. Now therefore be it resolved by the Raritan Township Board of Adjustment on January 6, 2022 as follows. 1, all regular meetings unless otherwise indicated shall be held at the on the first Thursday of each month at 7 p.m. at the committee court meeting room 160 at the municipal building located at 1 Municipal Drive, Flemington, Raritan Township, New Jersey, except when said Thursday shall be a legal holiday. 2, all special meetings, unless otherwise indicated, shall be held on the third Thursday of each month at 7 p.m. in the committee/court meeting room 160 at the municipal building located at 1 Municipal Drive, Flemington, Raritan Township, New Jersey, except when said Thursday shall be a legal holiday. or as listed below. Due to COVID-19
Number
global
three. These
pandemic.
are the important parts. I see number 3.
Number 3, due to the COVID-19 global pandemic, the meeting may be held over the Zoom platform. Notice of such will be listed on the meeting agenda and posted to the township website 6 days prior to the meeting. 4, the dates for the board's 2022 regular and special meetings are as follows. And those dates are January 6th, January 20th, February 3rd, February 17th, March 3rd, March 17th, April 7, April 21, May 5, May 19, June 2, June 16, July 7, July 21, August 4, August 18, September 1, September 15, October 6, October 20, November 3, December 1, and December 15. Number 5, the reorganization meeting for 2023 will be held on January 5, 2023 at 7 p.m. in the municipal building, and the meeting may be held over the Zoom platform. Notice of such will be listed on the meeting agenda and posted to the township website 6 days prior to the meeting. 6, a copy of this resolution shall be posted and mailed in accordance with the Open Public Meetings Act, NJSA 10:4-18. To be further resolved, be it further resolved that the Raritan Township Board of Adjustment may hold on-site inspections on the Saturday preceding the meeting date. The time of the site inspection shall be determined by the Township Planning Office. The site inspections will begin in the parking lot of the municipal building and then proceed from site to site.
I'll make a motion to approve the resolution
Do
for
I
the
have a
meeting
second?
schedule.
Thank you, Cynthia. Do I have a second?
I'll second Kevin Cole.
Thank you, Kevin. Roll call?
Jackie, that was Kevin on the second. Miss Cynthia Schaefer,
Yes.
Mr. Roger Aaron's.
Yes.
Mr. Kevin Cool,
Yes.
Mr. Randy Block,
Yes.
Mr. Steve Farcio,
yes,
Mr. Jim Ferrero,
yes,
Mr. Brad Perry.
Yes.
And Roger, Jackie just texted me and wants to know if anyone made a motion to excuse Bill Cummins' absence.
We did not do that.
Oh.
We should.
Thanks,
Okay.
Jackie.
Would somebody like to make a
I'll
motion?
make a motion to accept the excuse for Bill Cummins to not attend the meeting.
I second that. Randy Block.
Thank you, Randy. Cynthia, roll call?
Miss Cynthia Schaefer,
Yes.
Mr. Roger Aaron's.
Yes.
Mr. Kevin Cool,
Yes.
Mr. Randy Block,
Yes.
Mr. Steve Farcio,
yes,
Mr. Jim Ferrero,
yes,
Mr. Brad Perry.
Yes. Okay, next item on the agenda is the 2022 rules and regulations.
Right, now, this one, you
And-
don't have to read the resolution, but if anyone has anything they wanted added or corrected in the rules, which were also handed out with a date of January 6th, they should speak up.
Yes, I do have a correction. That is on page 5, Rule 1:3, under meetings. And it says, regular meetings of the board shall be held at the municipal building at 7:30 on the first Thursday of each month. We have changed that to 7 o'clock.
Yes, we did.
So if that could be changed, I would appreciate it.
Roger, what paragraph are you looking at?
This is paragraph
Page,
1.3-1
right.
on page 5. And it's the second line.
Got it, thank you.
So with
Any-
that revision, does someone want to make a motion to adopt the resolution adopting the rules and regulations?
Do I hear a motion?
I'll make a motion.
I second that.
Thank you, Randy.
Miss Cynthia Schaefer,
Yes.
Mr. Roger Aaron's.
Yes.
Mr. Kevin Cool,
Yes.
Mr. Randy Block,
Yes.
Mr. Steve Farcio,
yes,
Mr. Jim Ferrero,
yes,
Mr. Brad Perry.
Yes. All right, we have only 2 more resolutions to do. The next resolution is the designation of newspapers to receive meeting agendas and notices of applications for 2022. Whereas the Open Public Meeting Act
I'll tell you what,
specifically.
on this one, if you just list the two newspapers. this
Okay,
one's
fine.
I agree that they should, all the others should be read so everyone, including new board members, understands what we're doing. This one, technical, just name the two newspapers.
Okay. The two newspapers.
Actually, three
are
newspapers.
Are the Hunterdon County Democrat and the Courier News,
And the three
the Star
newspapers,
Ledger.
Star Ledger,
So there are actually three.
right.
I'll make a motion to approve.
Second, Kevin Cool.
Roll call?
Miss Cynthia Schaefer,
Yes.
Mr. Roger Aaron's.
Yes.
Mr. Kevin Cool,
Yes.
Mr. Randy Block,
Yes.
Mr. Steve Farcia,
yes,
Mr. Jim Ferrero,
yes,
Mr. Brad Perry.
Yes.
This next one, I think you should read.
Okay. And I have a correction to the next one. Amy, on the second whereas, a third line reads completeness waiver determinations are delegated, it should say to a committee. All right, this is resolution delegating completeness and completeness waiver determinations to board engineer, township assistant planner, and board secretary. Whereas NJSA 4055D-10.3 provides that application completeness and incompleteness determinations can be made by the municipal agency or its authorized committee or designee, and that requests for waivers of completeness submission requirements can be made by the agency or its authorized committee. Whereas the board has determined that it will save time and applicants' escrow expense and be more efficient if completeness and incompleteness determinations, as well as completeness waiver determinations, are delegated to a committee consisting of the board engineering expert, township assistant planner, and board secretary. Now therefore be it resolved by the board by motion duly made and seconded on January 6, 2022 as follows. Delegation of authority to board engineering expert, township assistant planner, and board secretary to grant and deny completeness waivers and to certify future completeness and incompleteness of applications. The board hereby delegates authority to a committee consisting of the board engineering expert, township assistant planner, and board secretary to make completeness and incompleteness determinations, as well as to grant and deny completeness waivers in accordance with NJSA 4055D-10.3.
Yeah, and Amy, since these are all the equivalent of approval resolutions, these are not memorializing resolutions. We can cross out the whole voting thing, and you can have Roger during the week sign this one, because you should put his name on it.
Okay.
Okay.
But
Do we need a motion?
A motion to adopt.
Okay, could I have a motion?
Motion to adopt.
I'll second that. Amy, roll call?
Miss Cynthia Schaefer,
Yes.
Mr. Roger Aaron's,
Yes.
Mr. Kevin Cool,
Yes.
Mr. Randy Block,
Yes.
Mr. Steve Farcia,
yes,
Mr. Jim Ferrero,
yes, yes, yes.
Mr. Brad Perry.
Yes. All right. For those of you in the audience, I thank you for your patience. Normally, this is done at a reorg meeting.
Two resolutions.
We have two
Yeah.
resolutions to
Oh,
go.
sorry. How did I let those slip by?
Need them?
Okay, wait a minute, what did I do with mine? I got them.
Oh, we're doing the second one. You can see it. Here, Roger. Here you go.
Okay, thanks.
Sure.
Yeah, I got that one here. Okay. Okay. All right. First resolution we're going to adopt tonight is Raritan Township Board of Adjustment Satrajit Sil, 37 Tiffany Drive, Block 44, Lot 24.3, application number 06-2021, resolution memorializing grant of C2 variance for deviation from hard surface coverage requirement to allow construction of accessory deck and patio. Resolution number 2021-18. Can I have a motion?
And this one is dated January 5, 2022, and it's version 5.
Version 5, correct.
I'll make a motion to approve this resolution.
I second that.
Okay, for Jackie, Cynthia made the motion, and I heard Randy second it.
Correct.
Okay.
Ms. Cynthia Schaefer,
Yes.
Mr. Roger Aaron's,
Yes.
Mr. Kevin Cool,
Yes.
Mr. Randy Block,
Yes.
Mr. Jim Ferraro,
yes,
Mr. Brad Perry,
Yes.
and Mr. Bill Cummins is absent tonight.
Our second resolution for adoption tonight is Sumash Kalaporakal, 24 Tiffany Drive, Block 44.02, Lot 26. Application number BOA 05-2021, resolution memorializing grant of C2 variance for deviation from hard surface coverage requirement to allow construction of two-story addition to existing dwelling and patio area. Resolution number 2021-19. And I have one correction on that resolution on page 10, Amy. And John may have given that to you already. It's
On
number
which page?
7.
There is no page 10.
Page 10, number
Oh,
7,
I'm sorry, I'm on the wrong one.
entitled Stormwater Management
Yep.
Measures.
Yep.
And second line reads, demonstrate through hydrologic and hydraulic analysis.
That's correct. That's the way that it was written in Tony's
No,
report.
correct,
Okay.
but he's correcting Tony's underlying report had the error in it. It's hydraulic and hydrologic analysis.
Right.
Yeah, in this
Yep.
particular memo report, apparently you have hydraulic twice. And the first one should have been hydrologic, correct? Roger got the eagle eyes, he caught it.
So what are we amending this to?
We checked it.
We did check it.
Tony,
but-
listen to me. I get so much of my stuff corrected, which is good, don't get me wrong. It's about time he got you on something.
So what do you want me to change this to?
The first hydrologic should be, the first hydraulic should be hydrologic.
Correct. Any other corrections?
I'll make a motion to approve with the corrections.
And again,
Thank-
did we give the date in the version?
Yes, the date is 2022, January 5, version 4,
As corrected.
as corrected.
Cynthia for approved. Kevin, second.
Roll call, please.
Ms. Cynthia Schaefer,
Yes.
Mr. Roger Aaron's.
Yes.
Mr. Kevin Cool,
Yes.
Mr. Randy Block,
Yes.
Mr. Jim Ferraro,
yes,
Mr. Brad Perry,
Yes.
and Mr. Bill Cummins is absent tonight.
All right. Thank you very much for your patience. Now we'll move on to tonight's applications. First application before us is Matthew Benedict
No.
and,
No, you
No,
missed
no,
one.
no.
No.
First application,
sorry,
right?
We-
Flemington 202 Properties, even
Oh, yes.
though you have inside information,
correct.
which you have to share with everyone, that they're not going to be heard tonight.
Yes, that will be heard on March the 17th.
And they have to notice, they have not noticed. So if anyone is here in the public, either in the chambers right now or on Zoom, and they're here on Board of Adjustment Case 11-2021 Flemington 202 Properties, they're not going to be heard. They didn't notice. They're going to be heard on March 17, assuming that their notice is in order. So everyone will be getting a notice.
Don't say the March 17th. They may be before if somebody cancels.
Okay,
Okay.
So
All right,
it's
so
up in the air.
we're not.
Could not hear that.
We're not assigning it a particular date because we don't have to because we're not carrying it because it's not open and there's no notice. They're going to send a notice out.
That's
Is
correct.
that correct?
Correct.
Okay.
Hey,
Okay.
I have one question. John, can you call me real quick? I have a question for you.
Yep.
Thank
Hold
you.
on, can I mute yourself? I'm gonna step out of the room.
Yep.
You wanna take like a 3-minute recess?
Yeah. Why don't we take a 3-minute recess? We'll be back at okay, I'd like to call meeting back into order, please. Okay, our next application is BOA case number 14-2021. Application Matthew Benedict, location block 44.02, lot 30. Application C variance for pool and pool house causing impervious coverage overage. Mr. Benedict?
Roger, before you start, this is Steve Farcio. I'm going to recuse myself, okay, on this matter.
Thank
There's
you.
there's basically an appearance of conflict. I just don't want to, I want to avoid that.
Thank you.
Okay, so you're gonna mute yourself and knock off your video and you'll come back in when the next case is called, right?
Steve will call you.
So let's have Mr. Benedict. You can sit right in front of the microphone. Let me get the microphone.
Thank you.
And then I assume you're gonna have 1 or 2 witnesses?
Yes.
2 witnesses, 1 witness. So when it's your
John, are these expert witnesses or fact witnesses?
find out. So, Mr. Benedict, who is your witness gonna be?
Tonight will be Larry Morgan.
Your witness is gonna be who?
I'm sorry, Larry Morgan.
Larry Morgan. And Mr.
Lawrence Murphy, I'm sorry.
Okay, and you're a professional engineer?
Yes.
Okay, so hold on. So let's have Mr. Benedict, Mr. Murphy, Mr. Hajar, and Mr. Vaccarello. Let's all stand up. Raise your right hands, and do all 4 of you swear that the testimony you're going to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes.
Sure, yes.
Okay, so start down with Mr. Murphy. Get your mic. You guys can sit. Identify yourself for the record. We have to speak slowly and clearly because our board stenographer is on Zoom tonight.
John, do we have to qualify Mr. Murphy? Do we have to qualify Mr. Murphy?
After.
We got to swear. Gonna swear him in. Get them identified for the record first.
My name's Lawrence G. Murphy III with Greenside Engineering Consulting.
And you're the applicant's
I'm the
professional
applicant's
engineering
professional
expert.
engineering expert.
Okay, Mr. Murphy, introduce yourself to everybody.
Lawrence Murphy.
Oh, sorry. Mr. Benedict, introduce yourself to everybody. That's what you guys are looking at me funny. I'm saying, what's so funny about that? Now I realize what's so funny.
My name is Matthew Benedict. I live at 10 Aaron Place here in Raritan, New Jersey. I'm accompanied with my wife Cindy sitting behind me.
Okay, and you're the applicant.
I am, yes.
Jeff Vaccarella, Township Assistant Planner.
Tony Hajar, Board Engineering Expert.
Okay. Let's hand it over to Mr. Murphy, or you want to say something first?
I'll introduce. So, first of all, I apologize for botching Mr. Murphy's name. I think my nerves got the best of me this evening, but thank you for the opportunity to come and present this evening. Again, my name's Matt Benedict. I live here at 10 Aaron Place. I'm accompanied with my wife, Cindy. We're celebrating our 15th anniversary next week. We live in Raritan Township with our 2 children, Daniel, who's 8, and Ryan, who's 11. We moved to Flemington, New Jersey from Doylestown, Pennsylvania. And we moved here to be closer to family and friends. And what brought us to Flemington was just the land. We love the town. We like the community. The friends here that we've known had spoken very highly of it, and the Flemington Raritan area has lived up to be everything that we've expected it to be. We did build in the Mountain View community on Route 12. I apologize, my mask keeps falling. Where, we had the opportunity to customize our house and pick the lot that we were looking for, as well as become members of a developing community where we would be with people our age, and we knew that our children would grow up with friends of,
Yeah, gotta go nice and slow.
I'm sorry, with friends their age as well. When we picked our home, there were multiple things we were looking at. One, we were looking at, ensure we were close to the baseball fields and the playground areas that we had in our community. But we also wanted to pick a lot where we could grow and ultimately build the outdoor living space that we were hoping to build. We did choose a lot on a cul-de-sac in Aaron Place, where we did pay a significant premium for at the end of the cul-de-sac. It overlooks the common area. It also overlooks the Raritan Flemington. We have views over the hill, so it's a beautiful property, and we were excited to build our house there and plan our family there as well. In 2015, when we moved in, well, actually, I guess we moved in 2015 and 2016. We employed Toll Brothers to build a patio and a pool for us. We elected to do it in 2 phases. We'd worked with Toll Brothers at the time, so we had a phase 1 plan and phase 2 plan. The phase 1 plan was the patio that we had completed in 2016, with phase 2 being the pool, which we were going to complete at a later date. We had elected to complete that pool at a later date for multiple reasons. One, we had 2 very young children at the time. We weren't comfortable building the pool with the young children. So we were going to wait. We also needed to save up a little bit of money. And then those were the 2 main driving reasons. In 2016, we completed that patio. And in 2019, we then applied for the pool permit, and we found out that the impervious space limitations had changed on our property, which is what brings us here today for the variance request. I don't know that I have anything else to share unless there's any questions for me.
You purchased in 2015.
December of 2015, we closed on the property, yes.
Okay, and when you purchased in 2015, the hard surface coverage requirement was what percent? If you don't know, maybe.
It was 40%.
I believe it was 40% until it was amended in 2006.
Yeah, the documents that we received upon closing from Toll Brothers all state 40%, and we actually, I worked with Nick Retta, who is the Toll Brothers engineer, on the patio that we had permitted for in 2016 after our closing. Upon the completion of that patio, Nick Retta actually, and this has come up, and I was kind of prepared for this, but Nick Retta, who's the engineer for Toll Brothers, actually made the comment, "Here you go, Matt. We did all the calculations. You're not even close to your maximum impervious space. Your driveway expansion is about 115 square feet, still leaving you plenty of room
I'm
for-"
sorry, you have to slow down a little.
That's our court reporter speaking. You have to go nice and slow.
Okay. So would it be best to turn it over to you at this point? Okay, I'm going to turn it over.
What, Tony has a document where it does say 40%. So I just want to get the facts straight. You shouldn't get nervous, just so you understand.
Okay.
Because this board has heard, I'm going to say, half dozen of these cases where it was 40% reduced down to 20. What the board has said, in all those other cases, is there's no justification for a C1 hardship variance because the change from 40 to 20 impacted everybody. And for a hardship, it has to be specific.
John, I'm not sure if Jackie's getting you.
John, I can't hear you either.
You have to use the microphone.
Yep, I'm sorry. Besides speaking slowly, which has taken me about 6 months to learn how to do, you got to speak into the mic, which I have not yet learned how to do. You're better at that than me. So, as I was saying, the board has heard probably 6 of these sort of cases where homeowners, some have bought when it was 40%, then it was changed to 20. Some, and I just want to get the facts straight, but some have bought after it was already changed to 20. But no matter what, the board has said so far in all the applications it's granted and in all the resolutions it's adopted, even one tonight, I always butcher your name, Calaparuco. Ooh, I got it. That there's a C1 hardship variance can't apply because this thing applies to everyone because it was across the board zone change back in 2006. But the board has granted C2 variances, which C2 variance is where some benefit of the municipal land use law is going to be advanced and the benefits substantially outweigh the detriments. And what the board has done in every case, as Tony has laid out in his memo dated January 4, is if through engineering, you can make the property act as if it only has 17%, then not only is there no harm in granting the variance to exceed the 20, but it's actually a positive reason to grant it because the property is not just going to act like 20, it's going to act like 17. So I just don't want you to get nervous, okay? Because I can't guarantee anything, but that's probably what's going to happen here. Having said that, we have to lay the facts out. Tony, why do you have a document done by Toll Brothers engineer that says it's 40%?
John, turn the mic. Thank you.
So the Hilltop project started in, I believe, in 1998. And I believe that the center of town, including this lot here, were included in to develop, I believe 600 or 700 units. And it kept changing. So my understanding is since they applied in 2005, they had the 40%.
So put it this way, the development, right, under the municipal land use law, they got subdivision approval prior to the ordinance change.
That's correct.
Then there is a statutory protection period. If they got subdivision approval prior to the ordinance change, so if they got subdivision approval in 2005 and the ordinance.
No, they didn't get subdivision approval until 2011 or 12. I don't remember.
If they didn't get subdivision approval in 2011, that is even more confusing to me. Who prepared this document? Who prepared that survey?
Toll Brothers. Toll Brothers.
All I can say is, it seems to me that the Toll Brothers engineer made a mistake. But let's assume for argument's sake that they had gotten subdivision approval in 2005, which Tony's telling me no, it was 2011. But even assuming it was 2005, they have a statutory protection period against ordinance changes for 2 years, which can be extended 3 times, 3 one-year periods. So in the best of cases, it would have gone from 2005 to 2010. Anything after 2010 would be subject to the new ordinance requirement. So even if they had the protection period.
Wasn't in 2005.
I understand, but if it's 2011, I don't care what Toll Brothers engineer says. I know what the ordinance says.
So when they put the patio in 2016, was that he was under the new ordinance?
No.
Jeff,
This was based off of the subdivision design, but they never, that doesn't mean that that's 40 per lot. The resolution.
I'm not hearing this.
Again, it doesn't matter if the applicant amends its application to seek a C2 variance instead of a C1 variance, all this is irrelevant. Now, because I looked at the application form and checked off C1 variance hardship. I'm just telling you, if you say, I'd like to amend the application for a C2 variance and not a C1, we can dispense with this whole discussion because in my opinion, it doesn't matter what you can say to me, but the ordinance is the ordinance. It was changed in 2006. It doesn't matter what the Toll Brothers surveyor put on that plat.
We're happy to amend it.
We're happy
a
to amend.
C2
Okay,
from a C1.
okay. So I assume the resolution is going to explain that a C1 is not applicable because the ordinance was amended and it impacted everybody.
John, I have a question.
Yeah.
This is the Toll Brothers division. Okay, so before this applicant's too far, do you think his property lines are correct?
Put it this way, I have no idea. The reason that question is being raised is because we had some other applicants come in,
Six.
Oh, no.
Toll Brothers surveys, and the property lines were also wrong. And the reason I know that Cynthia is asking, Cynthia was last year's chair, she's the chair pro tem.
I don't believe the property lines were wrong. The lot coverage was.
The lot coverage calculation was wrong.
Okay, so,
Yeah.
all right, so it was just a lot. Okay.
But the board has had one case where the lot lines were wrong.
Yeah.
And they had to come in and seek a bunch of variances on that. And so I think what she's probably getting to is a little further down the road this evening. And that's probably gonna be, you have and I don't know if it's the proposed.
I believe this lot was resurveyed. Correct me if I'm wrong.
Okay.
You're
good.
correct.
So when you're saying, see, what I see on it, proposed permeable pavers, right? You have those pavers 15.71 feet from the 15-foot setback. And you have the proposed pool house 15.62 feet from the 15-foot setback. I looked at the section you provided with the pool house, and it doesn't look like it's concrete. It looks like it's stone. But I think where Cynthia's going is, you may want to suggest, propose having it more than 15.71 and more than 15.62 for your own protection, just in case. Let's say the board grants you the variance for those and grants you the variance for the hard surface. And the resolution is going to say it can't be any closer than you're showing on this plan. And then if you find out it is closer, you're going to be like Mr. Caliparo, who's sitting out there. He's coming back. He started. When did you start, Mr. Caliparo? How many months ago? His hard surface was wrong by a surveyor. Then he came back. The board granted that, and now he also has a shed problem. That's what he's coming back for after this. So he's had to be here 3 times. Not that he doesn't like these guys, and not that these guys don't like him, but neither of them enjoy the fact that he's had to make 3 trips.
Can we qualify me as an expert?
Yes.
So I can talk.
Yeah, that's a good. Can you, why don't you give the board the benefit of your educational background, your work experience?
Sure. So my name is Lawrence Murphy. I graduated Rutgers University with a bachelor's degree in science. I've been practicing civil engineering for over 24 years, focusing on land development applications such as this one for 22.
You have to slow down.
Sorry. Graduated Rutgers University with a bachelor's degree in science. I've been practicing civil engineering for 24 years and focusing on land development applications for 22 years. I'm licensed I'm a licensed PE in the state of New Jersey. I've been qualified as an expert over 100 times. And I did testify before I believe it was the Planning Board of Raritan back in 2015 in support of Citizens for Responsible Development in Raritan Township, objecting to the Christie Estates application.
Any board members have any questions on his qualifications? Is there anyone in the public here other than the applicant and friends of the applicant? No. Board chair, you accept him as an expert? Oh, pardon me. Do we have any? We have people on Zoom. We have board members on Zoom and we have residents on Zoom. Any residents or board members on Zoom have any questions for the applicant's engineer's qualifications?
No.
You accept him as an expert?
On behalf of the board, I'll accept him as an expert. Yes, thank you.
Okay, so I did, just to contribute to the previous conversation, not in support of a C1, because we've modified it to a C2. I do have a copy of the recorded plat filed with the county clerk that does show 40%. I can provide that
Well,
to
no,
you.
it's, the plat says 40%.
That's what was recorded with the county
Correct.
clerk. Okay,
That doesn't mean that that's correct. It means that that's what the plat says,
Yep.
because that's what someone put on it, and no one caught it.
agreed.
If I was reviewing it, it wouldn't have gone through that way, is all I can tell you.
Yeah, so it definitely can be confusing.
Okay, but you're looking for a C2. So you've seen Mr. Hajar's memo, correct?
I have.
So why don't you just go through his memo and explain to the board, because presumably if you agree to do everything he says in the memo, or if you've already done some of the stuff he said in the memo, presumably on the same theory that the board has treated these other applications, they're going to treat this one in a similar fashion.
Yeah, so we met with Tony regarding this project. In regards to the review letter dated January 4th, 2022, issued by Tony Hajar, comment 1 is asking provide testimony in regards to the existing patio paver and permeable pool. Just to provide that testimony, we're proposing permeable pavers in lieu of hard surface to minimize the impervious surface on site. 2, we're in agreement to provide stormwater management to meet the 210 and 100-year storm hydrographs, so the site acts as a 17% impervious site. This will provide for reduced flood control and also increased recharge, which supports the MLUL under 40:55D-2B, which is to secure safety from fire, flood, panic, and other natural man-made disasters, and also advances 40:55D-2J, which promotes the conservation of historic sites, districts, open space, energy resources, and valuable natural resources, which is recharging aquifer. Hello. Right, thank you. Which is recharging, basically valuable natural resource is aquifer, and providing recharge which exceeds or meets a 17%. We're actually increasing the recharge on site by about 38%, which is significant. That is number 3 in the letter, which is basically demonstrate through the hydrologic and hydraulic analysis that the site can maintain 100% of the average annual pre-construction groundwater recharge, which we agree to meet. We also agree to number 4, which is to have witnessed infiltration testing, soil log descriptions. We agree to number 5, which is inspection escrow account. Number 6 is a discussion point, which is ask the question, can the pool be relocated closer to the building and to reduce the hard surface count? From an engineering perspective, when the applicant came to me, he was actually asking for more. He was asking for patio fully surrounding the pool and a larger patio area. We actually shrunk that originally to not have patio or hard surface on the southern side of the pool, which is atypical. And we brought it as close as we could while allowing a lounge chair to fit on the north side of the pool without creating drainage problems or earthwork and unbalanced spill against the foundation wall. So we really can't bring it any closer from an engineering perspective without going to a very small 3-foot patio around the pool, which isn't aligned with the size of this property or the stature of the house and the anticipated use by the client.
Yeah, just on this point, I just want to tell you where Tony and Jeff are coming from. On those other 6 applications I was talking about, those applications where the hard surface coverage requirement had been reduced from 40% to 20%, the highest the board has granted so far is approximately 30%. So if they grant this one, the 37.63, this is going to be the highest amount of anything. That's why Tony is wondering, is there anything you can do anywhere to try to get this thing down so they don't, even though, it's case by case and nothing's supposed to be a precedent, so they don't, and so someone else doesn't come in and say, hey, now, I heard what you did for Mr. Benedict. Why can't you do that for me?
So I think there's a substantial difference between this application and other applications, which is all of the hard surface we're proposing, with the exception of the pool, is actually permeable pavers, which is a green infrastructure that's been recently approved by DEP.
Right, but if the standard was impervious versus, yeah, that it wouldn't count, but their standard in Raritan is hard surface.
Okay.
In other words, is there anything you can do, for example, the proposed pool house? Can you, if you move that more onto the patio, you would eliminate some hard surface under it, right?
So I actually had this discussion with the applicant prior to coming. We looked at it and evaluated how much we could remove without substantially impacting what he's looking to accomplish. And I think the number was about, I just want to see.
That's a good point.
10%.
To get it down to 30%, how many square feet would you have to eliminate?
Give me 1 second.
Yep.
So to get it down to 30%, you would actually have to eliminate all of the hard surface around the pool. They would have no patio. And you would actually have to eliminate, I believe, some of the pool also. So it would be,
Well, let's put it this way. I represent the board. I don't represent Tony. Tell them what your thoughts are.
Well, our thoughts is, besides, I don't think the pool house is gonna make a big difference. But in my opinion, if we shift the pool towards the existing patio, I think that's gonna accomplish a lot. I don't have a number, but
what? Sure.
Would it be helpful if the board takes like a 5-minute recess and the 4 of you put your heads together and see if any of their ideas are amenable to you? You might come back and say no, and then the board's got to make the call on it ultimately, but maybe some of what they suggest might be amenable, because if you can get them to sign on to it, it's going to make things a lot easier.
Sure, we can take a recess.
Could I don't know if a comment for context, well, if folks were looking at it on break. The existing patio there that we have today is a raised patio, and around that patio is a 2.5-foot wall, which is actually a retaining wall. And when we looked at moving the pool closer, and I'm willing to look at all options to reduce this, to help this get this approved, but moving the pool closer, the existing patio doesn't function as patio for the pool because of being raised and having a wall. And we are planning on putting a fence between the existing patio and the pool area to separate the two for safety concerns. So those are just some reasons my wife and I felt that, it was really challenging to move it closer, but absolutely willing to discuss this over recess. Just wanted to add context.
Thank you.
Okay.
5-minute recess.
Let's come back at 8:25.
Yes, I am.
Okay. So we're now back in session after a good 20 minutes of talking. So maybe we'll ask the applicant's engineer, Mr. Murphy, to describe to the board what the applicant's revised proposal is.
So after discussing with the township engineer and township planner, we're willing to reduce the square footage of the new patio and the total hard surface coverage on site to 35.6%.
Okay, just to be clear, the proposal in the application was 37.63, and what you're saying is the applicant has come back with proposing to eliminate how many square feet to get it down to 35.6?
It's approximately 2% or 520 square feet. And I just want to, we have approved, or what was granted by the township was 6,788 square feet on December 16, which is in excess of the, I think it's 25.5% or so.
Okay, now, so what you're saying is you have a permit that allowed 6,788 square feet of a patio,
Correct.
which would have brought it up to 25.5%, even though the ordinance said 20%. And just like I said in the little off the record thing we had, no one's looking to take that back from you because you have a validly issued permit, even though it shouldn't have been issued. But what was the patio built at? Was it built at 6,788 square feet?
I believe it was built 500 square feet bigger.
Right, so the patio that was built deviated from that permit by an additional 500 square feet. But, so the 25.5%, that's what it would have been if it was 6,788 square feet.
Yes.
Okay,
There may have been a driveway permit issued also after that, that may account for some of that 500 square feet,
After the
but
patio.
okay, and you're proposing to eliminate 520 square feet, and where would the 520 square feet be eliminated? Not on the existing patio?
not on the existing patio. It would be eliminated within the proposed permeable pavers by shrinking the space, consolidating, moving the cabana in a little closer and just shrinking the overall size from the outside in. And I'll have to work with my client on that as to exactly where, so we can get a usable patio while eliminating 520 square feet, which amounts to about a third of the proposed patio. So it's a substantial
So
reduction.
that's the proposal from the applicant to the board in response to Tony's request to decrease the size to try to get it below the 37.63.
So 36.5 is the final number that you're proposing?
35.6.
35.6, okay.
From 37.63 down to 35.6 is the proposal they're putting on the table right now.
Correct. I would like some latitude with eliminating some of the existing hard surface lot coverage in case my client wants to remove that versus shrink the patio. So I don't want to be just bound to the new patio.
Tony, what was the largest percentage that we had on any of the previous applications for
I believe it
Mr.
was
Sue?
around 29%, maybe the most 30.
Okay.
We never went over 30, that's for sure. But it was around, I think we had one about 29%.
Mr. Murphy, Mr. Benedict, you know, I'm going to suggest to you that you may want to come back again and see us and reconsider this. That percentage is so much higher than anything that we've granted before. And that sets a very bad precedent for us.
Mr. Murphy, how about if you take that walkway that we discussed and put the grass pavers instead? How much would that,
In other words, eliminate the 520 square feet plus
that walkway?
that walkway.
So that walkway, I would say that's about 200 square feet.
Now, is the walkway currently 200 square feet?
Yes.
Okay, so are you talking about totally eliminating it or replacing it with?
With the papers that we discussed, the grass papers.
So what's being discussed is they make this paver where like half of it is grass.
Yes.
So it would, if it was 200 square feet, it would basically carve off an additional 100 square feet approximately.
Probably more than 100.
Depending on what you use, if you use a poly grid, would cut out 80-90%.
So
That'd be 180.
okay, so if you did that, what would the percentage get reduced to? From 35.6 to what?
It would get reduced by 0.6% to 35%.
Bring it down to 35%. Roger, you still suggesting a 35%? Come back?
With all of the others, the highest one we've had in the past is just a little less than 30%. I still think that's pretty high. It's unfortunate that the original patio was over constructed or overbuilt. I would really hope that you could come back with a revised plan. I don't want to turn you down. We want to work with you, but I think you need to work with us too. How do you feel about that?
So I can appreciate that, and I'm willing to work. I just want to put some context to what that means. 30% would allow us 7,918 square feet, where right now we have 7,303 square feet. That wouldn't allow the pool. You'd have to shrink the pool, have no patio, no cabana, no pool equipment, nothing. And then you'd end up with a smaller pool. We'll call it a 20 by 30 foot pool. So which is actually a small pool in, the big scheme. It's not a large pool. Generally, people like the 20 by 40, 800 square feet. So that would allow us less than the pool we have and nothing else. So in order to actually meet the 30% and have any patio around it, we'd have to essentially scrape the existing patio,
I understand. Let's try.
remove it, and then rebuild a smaller one.
Let's try this. Try this.
One second. Mr. Murphy, how much was the overage again?
The overage was
From the permit to what was built? 526 or 520?
I think it was 430.
No, was 500?
The permit allowed 6,788 square feet.
And we have 7,303. So I'm going to do that math.
Right, just do that math and give us the number, please. It's going to be a little over
515 square feet.
515 square feet. Because another way of thinking about it is you had a valid permit to go to 25.5%, right? You had a
Yes.
valid permit to go to 25.5%.
Yes.
Let's round it down just for argument's sake. You had a valid permit to go to 25%.
Yes.
What would an additional 5% get you? Would it get you to pool? Because the reason I'm saying this, even though that permit should not have been issued, it was issued. Okay, they relied on it. So maybe they could be given some sort of credit, so to speak. Maybe if the board were to grant the application, I could have something in that resolution. Maybe it could even be a little bit of a hardship thing, which we don't normally do, based on the fact that they had a validly issued permit. So it's not purely C2. And I don't know how much, to give a credit, but what would an additional?
So 5% gets you 1,320 square feet.
And what's the size of this pool right now?
770.
So if that gets you the pool would.
The other thing that we should consider also is they're proposing permeable pavers.
Yeah.
And taking out the 515 square feet, they are left with 1,174 square feet of permeable pavers. That equates to 4.44%. So maybe we should give them some credit towards that as well.
Yeah, because the proposal as it stands right
Yeah,
now,
when we can make that
has-
part of this, that we can make that part of the C2. It's going to be, unfortunately, a complicated resolution, but this might be a way to get there without creating the bad precedent.
yeah, if you would take into account the permeable pavers and exclude them, then we have a hard surface of 31.2% as shown on the plan, not based on what we're discussing. Because that will actually come down below 30 when we start to eliminate. Well, it won't actually, because it'll be 31.24 because all of the pavers are eliminated. And if I continue to eliminate some pavers, it's still not going to change from 31.24.
But on that theory, we could say that it's the equivalent of 31.24.
Well, he's gonna, well, yeah.
Again, I'm thinking in terms of the resolution, the equivalent. Now, right now, we're in the dead of winter. There's going to be a snowstorm tonight, right? When, assuming that they granted this approval, when were you planning on doing the construction?
As soon as possible.
Well, as soon as possible. You're not doing it anytime soon.
So they
When-
should-
Okay.
So
What if, listen, if the construction department gave you the permit next week, you're telling me you'd go out and start constructing?
Yeah, dig the hole. in the
So
winter.
the challenge is we need to then do calculations, resubmit to Tony. Tony needs to review. Then the plans need to be signed off by the,
It's not just
the
that,
town.
it's more than that, because I'm gonna need, if the board wants to go with this theory, I'm gonna have to write it up in a resolution, and quite
Yep.
frankly, I'm gonna need assistance
Yep.
from both of you, and I would appreciate the assistance before the meeting. So
Gotcha.
I'm gonna suggest that it looks like we're moving in the right direction, but I'm gonna suggest that you seek an adjournment. So between the two of you, you present me with a theory, but with numbers.
Okay.
You see this is where I would like the board to go with this if they're inclined to grant it. And I think their guts want to grant it, but their brains are like, by granting it to you, they can't hurt themselves with other applications.
So I think there would be some benefit to asking for an adjournment so that
Right.
discussion can.
Right, but let me
percolate.
explain exactly what I'm going to be looking for. Okay, because I want you to write this down. The theory would be, they would grant the variance, but it's going to be a combination C2 and a C1. The C1 aspect of it is going to be because even though the maximum permitted under the ordinance was 20%, you got a permit, a validly issued permit that allowed up to 25.5 or whatever the number is, which you're going to have to get to me. So they're going to give you the C1 part of the variance is going to bring you up to 25 or what, 25.5 or whatever, right
Yep.
off the bat. So the C2 is not going to be for the full enchilada. In other words, even though when someone does the arithmetic, it's sure going to look like this thing is going to be somewhere about 35.6, but and the resolution is going to state that, but it's going to explain that the first 5 or 5.5 is a C1. The second portion is going to be a C2 based on two things. Based on, first of all, that you're going to make the property act as if it's 17%. That goes without saying. But the second part's going to be, you're using these permeable pavers, and you're going to give me a calculation that through the use of the permeable pavers, even though technically it might be 35.6, that's even going to act as if it is as low.
31.
As low as you can go. And I need those facts and figures so I can load that into the resolution and that we can present it to these guys at the continued hearing date, so they're comfortable that they're not going to create this, the domino effect, the bad precedent that other people, if someone else comes in and say, hey, you gave Mr. Benedict 35.6, you're going to say, here, read the resolution. Mr. Benedict didn't really get 35.6. He got a little over 30 because of all the special, he got a C1 because there was an invalid, there was a valid permit that shouldn't have been issued, but that's not, that can't be counted against him. And he's using permeable pavers and it's acting as if it's 31 something. You understand what I'm talking
I do.
about? Do you understand what I'm talking? Does the board feel comfortable with this concept?
I'm not sure I feel comfortable yet. I don't really understand these permeable pavers at all.
Okay, can you explain?
I can. So DEP recently adopted new stormwater regulations that are green infrastructure. And they're advocating for green infrastructure, one of which is permeable pavers, which basically is pavers that are separated to allow stormwater runoff to go through the pavers rather than sit on. Typically, what happens with pavers is the water runs off because the pavers are on compacted dirt and then filled with dense sand or even concrete that actually pushes the water off and acts like a pavement. But in this case, what you have is a paver or like a Lego block that's separated. The water runs through and underneath that paver, rather than dirt, is actual like 3/4 inch clean stone, 1.5 inch stone. So the water goes under it, which is very similar to an underground detention basin, which is just like a dry well. It's very similar to a dry well. And there's 2 feet of stone. I believe it's 2 feet of stone below the paver. So it actually acts as a detention basin right there. So the water sits, absorbs on the rocks and goes into the ground rather than running immediately off.
And I'm gonna ask Tony a question. If it were up to you, would you call permeable pavers hard surface?
It is a hard surface.
I know it is, but if it were up to you, I mean, does it really act like there's no pavers there? It absorbs all the water and I mean.
It does, yes.
Okay.
But based on the definition of a hard surface.
Right.
It is what it
The
is.
point is, it acts as if it's not, but technically it is, because the township ordinance doesn't talk about, like my other towns, it's impervious coverage. Here it's hard surface.
So historically, many towns have granted variances based on permeable pavers not acting as impervious or hard surface. DEP actually allows you to take up to 20% credit depending on the paver to be excluded from impervious coverage calculations. So I think across the state, it's a wide range of how people perceive it.
All right, thank you for that explanation.
I have a question. We haven't finished Tony's report. I just have one question. Number 12, there's a question that we'd like you to answer around the utilities. If you
So-
could just give that information now.
Sure. So it's anticipated to only have electric.
Okay.
There may be water that's brought out, but no sewer, no bathroom, no kitchen, no kitchen sink.
Okay. And the other question I have is in this recalculation and what you're doing here. I would ask that the setback for the side yard is very close, that 15.62 for the pool shed, the pool house, and the 15.71 for the patio. As you work through that, it would be helpful if that could come closer. And I'll just let the applicant know that if it stays there, we have had situations where the contractor, whoever you pick, has made mistakes. And then you end up back here, and we just had one where they agreed to cut off like 5 feet of patio, which I thought was silly. But again, if you can get it just that 15 feet off, and then when the contractor does it, please check.
So what I would suggest that would be even more helpful, taking it a little bit away can be
Yeah.
helpful, but actually having them have a surveyor stake the setback line
Yeah.
is just idiot proof.
Yes.
It's staked.
I'll challenge you on that.
Yeah, well, and then if something goes wrong,
Yeah.
then it's clear.
He has
either
an
the
argument to go back to
contractor
the
did it
contractor.
or the surveyor messed up. Both have insurance and the
Yes.
homeowner's not.
So it's not
responsible.
simply stake the
Exactly.
corners. They're going to stake the setback line and run strings.
Yes. And I think that would be the most effective for the concern along the western property line. I would recommend that just the property line is staked also,
That's-
plus,
Well,
plus that setback
plus the
line.
setback.
Yes.
Okay.
The other thought is, and I'm not sure the cost is to transform the existing.
I can't hear you, Tony.
I'm sorry. Is to remove the existing pavers and put permeable pavers on the existing patio. That will also help, but again,
It would. it
there's a
would help.
cost associated with it, and I don't know what it is.
Yeah, there is a cost associated because you're removing the pavers, replacing the pavers, ripping up the existing stone, yeah.
That existing patio.
John.
I know they're over 520 square feet, but the vast majority of the existing patio was constructed with a permit, even though it shouldn't have been issued. I'm normally 100% with you, but
And I would just ask that we just ferret out whether the addition to the driveway that was submitted for permit was issued or not, because that may account for that 500 square feet of additional area.
The driveway was extended with the permit in 2017 after the patio was finished. And that was done through the Toll Brothers company as well, and permits were obtained.
do we have them?
When you say Toll Brothers, you're saying you bought the house from Toll Brothers developers.
Yeah.
But the Toll Brothers you're referring to is a side or different company, a service company? Because you own the property, you're living there.
Yeah, so I brought the house from Toll Brothers,
Right.
closed with Toll Brothers, and that was the end of that interaction with the model home and the
Right.
representatives that worked there. They had, with them, they recommended Toll Brothers Landscape, and that's the company that comes and plants all the trees and maintains the commons areas. But they also offer, after you close, they'll come in and they'll do the stone facade, because when the homes are delivered, they're just delivered with like the, concrete steps. So if you want nice stone steps out front, that's when Toll Landscaping comes in and does that. So Toll Landscaping, we also contracted with them to build our deck. So they worked out of the model home. They were side by side, but I think they worked there. It was a separate entity.
That's what I'm interested in. Okay, it sounds like it was. Thank you.
Oh,
Mr. Murphy, how much time do you think you and your client would need to come up with a new proposal for us?
We can have it ready, for next month's meeting. We just need to make sure that we have a discussion, meeting of the minds, and craft this language, and there's enough time for that. So I'd like to ask for continuance to next month's meeting.
You mean, when could we get Mr. and Mrs. Benedict back on the schedule?
Unfortunately, I didn't take a picture of our board. Do you guys remember what we have on for the 3rd?
I'll tell you what, maybe someone can run down the hall and take a look when we call Mr. Calaparocco's case, and then we can let you know.
It's Shanty and Schnapp.
Schneider's coming back and Shanty is.
And then we also have applications on the 17th.
Schneibel is coming back with an issue like this one.
John, I'm gonna run down and get a picture.
Okay.
So,
And the board should remember that. Schneibel's coming back because you guys told them to try to get theirs low.
Yes.
I have the driveway, the zoning permit for the driveway, so it's approximately 75 square feet on one side and 122 on the other. So it's 197. And this is based on what was submitted. I'm not sure what was built at the end of the day.
Tony, that was part of the 37.63 figure that originally the Benedicts came up with, Mr. Murphy?
Yeah, right over here, Tom.
That's part of the 37.63, correct?
Okay. Thank you, Amy.
I actually ran, so I'm really out of breath. So the next meeting is ESCO. February 3rd, we have Salim Basha Abdul Bashir.
So that's the one with no access. I don't know if you guys recall, but
The second meeting in February, we have Michael D. Luis and Interstate Advertising.
What's on February 3rd?
Bashir.
Is that a whole, whole night?
my understanding is there's a lot of objectors on
Oh,
the
that's the,
application.
Right.
And this is the one with the access. They
Yeah.
claim it's 16.5 feet, but there's only maybe 12 feet. Wow.
can we,
I think you guys probably want to be, even though you probably squeeze the beginning, I don't think you want to be on the room full of projectors on a second case, just in case
Agreed.
someone gets some idea.
Agreed. Yep.
What's the next one?
February 17th, we have Michael D. Luis. It's for another C variance pool and front yard. And we have Interstate Outdoor Advertising.
And we devoted the whole meeting for them, but I squeezed somebody in.
My suggestion would be before Bashir, but
Listen. Before Bashir would be a thing to do,
Yeah.
but you just have to recognize that Bashir's going to attract a room full of people. Sometimes they don't care. Sometimes if they got nothing better to do, instead of going out to the movies. But if you're not willing to do that, it sounds like you're gonna have to wait till March.
March 3rd, we have Schneibel and Shanty.
I mean, we
well, wait,
promised
wait,
Bashir to be
wait,
first in that
wait,
meeting.
wait. Did we say that we would give Bashir the whole meeting?
We kind of did, and we promised them the whole, to be first as well.
We promised them to be first.
Okay, so we give them 2 hours
Yeah.
and we give, and they can come at the end and then
Is this-
they just don't.
Is this for the 17th?
This is for the 3rd,
Okay.
February
So
3rd.
we have 2 applications. We tell the first application you have 2 hours. The second application will be them. They have,
Let me ask you this. How much time do you think, if they come back, there's an agreement,
if they've met before
right?
and you understand what's in the resolution,
Yeah,
Right.
that's not going
And
to
so
take
if
long.
all of us are comfortable, how many minutes do you think this will take? No more than a half hour.
Yeah,
right?
20
Yeah.
minutes or so.
Right.
Because there shouldn't be a discussion on the percent.
Right, so you could give Bashir 2.5 hours and give these guys a half hour.
right, and then they don't come to the, here until the end,
Or if
until
you
those,
wanna see the show, you can come early and
Yeah.
watch.
so we do that.
But we have
and then-
no way
Well,
of
the thing
knowing
is,
if,
we don't know what's gonna happen with Bashir either,
What
so,
happens if Bashir shows up and says, we're not ready? to proceed?"
yeah.
yeah.
So be here at 7 o'clock, but realize that you're not gonna get heard most likely till 9:30. But if everything is, if all the i's are dotted and the t's are crossed, it looks like you're gonna emerge.
Or they can have March.
I would like to say we give them the last hour, and the only reason I say that is usually the one that's up usually drags off a little 5 or 10 minutes. We do have breaks. So we say they have the last hour, Bashir gets 2 hours. And we do have our 5-10 minutes in the meeting, the beginning.
Sound good for you guys?
Yep.
Okay, so let's make an announcement. The hearing on the Benedict application 14-2021 is gonna be continued without any further notice to.
I'm not hearing you.
I'm so sorry, Jackie. I don't know. You should.
February 3rd, right?
Yeah, so
February 3rd.
again, the hearing on the Benedict application, which is number 14-2021, is going to be continued without the need for further notice to February 3. You guys are going to be scheduled to be heard that evening at 9 o'clock. There's
But
an
come at
application,
7.
there's an application on 7, they're going to be given 2 hours, and you're going to be scheduled to be heard at 9 o'clock that night.
Also,
They'll be
because.
here at 7 though.
Yeah, be
Yeah,
here at
just
7,
in
just in
case.
case.
Right. Also, because of the fact that you're going to have a prior agreement where the minds have come together, the resolution shouldn't be that difficult to put together once that.
Roger, the this is going to be a complicated
I realize.
variance resolution.
I realize.
That's
Yeah.
all right. Roger's gonna read it.
You'll, believe me, you'll have some work to do. Okay. See you on February 3, but get a hold of Tony. If Tony wants to, hook me in, he will, but you guys know what I'm looking
Oh.
for.
Motion to adjourn.
No, they're gonna move.
I mean,
He might-
Thank you for your time. Thank you.
Okay.
We need a motion to continue
No.
until the third?
No, we just carried it.
Okay, fine.
Do you want to
Good.
ask Jackie if she's okay?
Yeah, I think we need to take a break from Jackie. Jackie, would you like a break? Jackie, would you like a short break?
Jackie, if you don't say anything.
Yes,
you're
yes,
either on
I
the
would.
break or- Okay,
Okay,
maybe she was on the break already.
we'll come back at about 9:15.
Ready to roll? Ready to
One
roll?
more minute.
Okay.
Everybody back?
Yep, we're recording.
All right.
Well, no, Jim. There's an empty chair with Jim.
right. You probably have to do that, right?
Jim, you there?
don't want to do that.
Let me get Jim.
Calling the meeting back to order. Okay, third application is BOA case number 33, 2021. Applicant is Sumash Kalapurakal. Location block 44.02, lot 26. Application C variance for shed. Thank you for your patience.
No problem. Thanks, Roger.
Let's get everyone sworn in. Everyone raise their right hands. Does everyone swear the testimony they're going to give in this proceeding will be the truth, the whole truth, nothing but the truth?
Yes, I do.
Can you identify, you're going to go right down the line, nice and slow, identify yourself for the record.
Yes, my name is Sumesh Kalapurekal, living in 24 Tiffany Drive, Flemington, New Jersey.
Yeah, Dr. Ella, Township Assistant Planning.
Tony Hajar, board engineer.
Okay, so Mr. Kalapurakal, we know that you were here
Yeah.
twice already. The board granted you the hard surface variance. They adopted the resolution tonight, and now you're back with it for a shed variance. Can
Yes.
you explain in your own words to the board when the shed was put in? We know that it's not 5 feet from the line, it's approximately 3.5 feet from the line, and why you can't comply to make it 5 feet from the line. Because as I understand it, you're applying for a C1 hardship variance.
C2.
A C2, huh? Okay, well, whichever,
Okay, whatever.
doesn't matter. You want to see variance.
Yeah, C variant.
Okay,
Yeah.
explain to the board nice and slowly.
So this is a corner property actually, and a lot of the history has been explained in the previous resolution.
Right, but
Yeah.
do it
It's
from
connected
this
to
one.
that because that resolution also has a point that I have to either move the shed or apply for a
Right.
variance within 60 days. And thanks to the township, they were able to accommodate me on this. And I just came back from my vacation yesterday and I did all the homework before I left. And then I was able to get into this meeting. Thanks for accommodating me. So the history of that is basically being a corner property and it's being very flat. The water is a bigger problem there. So water comes from my neighbor, from a corner lot, all the way it fills up the entire backyard actually. So Toll did a 4 times regrading the property. And
Okay, I just want to make, you said Toll regraded your property 4 times.
4 times, yes. Because it was not graded properly, they graded and then they wait for the rain. And when the rain comes in, it floods again. It's kind of repositioning the issue from one place to another place, but they didn't really fix it. The last grading was to put a catch basin and then catch the water and push it out to the outlet actually, and that's what they did. So the first 2 gradings when they did, the shed was not there actually, and then when I asked Toll, they said you can put the shed, no problem. We will make sure that it is not going to be a problem. When the rain came in after the shed, it was again flooded actually. when the.
Who
when the-
installed the shed, you or Toll?
Pardon?
Who installed the shed, you or Toll?
Myself, actually, with the shed, the construction company, basically. So they came and they did an assessment and they said 5 feet from, because I already have a permit approved on July 2017 to be the shed placed in a corner with the 5 feet from each, from the property line. But when they put in, they pushed it a little further, so it's not compliance to that permit.
Okay, so
actually.
stop. So that's what I was trying to say. You installed the shed, you believe you had it at 5 feet, and Toll pushed it to its ultimate location?
No, actually, I, based on the survey, actually, the toll survey, the shed was built, but then there was a lot of calculations that was wrong.
Just, I'm not understanding, explain.
Are you saying there was issue with the property lines? on
Not with the
survey?
property lines, the setback, actually. There was a difference in the setbacks and things like that. And that's what the new survey shows, actually.
Well, but you didn't stake it out. You just put the shed, you placed the shed on your property without staking it out.
Yeah, just Toll gave that pin corner property pin based
Yeah,
on
so
that.
he, was it
Corners.
the property corners, and he installed the shed, and based on the survey we received, it's actually 3.71 instead of being 5 feet away from the property line.
And when the shed was installed, the installer said that is the right location because even if the flood comes in, it won't be floating. But if you look at the pictures now, the water comes and it's kind of on the gate, actually. And if I move the
Okay.
shed,
Let me. So what happens is Toll put a catch basin at the end of by the property line in the front yard. And the water, the yard is graded, so the water goes from the corner of the back right corner to the catch basin. So if he moves the shed to be 5 feet, that shed is gonna be in the way of that
flow.
water. Yeah, thank you.
Thanks, Tony.
If that makes any sense, but. And the catch basin obviously cannot be relocated. You could do grading, but it's gonna be tough to take it back to that catch basin.
Now, the pins were correctly placed in the
I
beginning.
believe the pins were correctly placed, but again, since the line was the line staked out? I wasn't there when they put the shed.
No, the line.
You know, your eye is always, it's not 100% accurate. It's not like you're doing it with surveying equipment.
Yeah, I think when you stand on the property and look at, it's perfectly fine. But the only thing is, if you look at from a drone, then you can see it is a corner property. It's a slanting. It's perpendicular to the road, actually.
That's why we always tell people to run strings.
Yeah, that was a lesson I learned from last thing, which I need to.
And I witnessed the different stages of the grading by Toll. We had a lot of problems with that property. Water will come in from the adjoining property and will sit on his.
If the shed is moved, it's gonna be in the.
John, not hearing you.
If the shed is moved, Tony, you're saying it'll be in the way of the water, the stormwater runoff,
Yeah,
and so, and it won't make it to the catch basin.
that's correct.
And just to be clear, the property you're talking about is that the water's coming from is on Aaron Place?
It comes from both Erin Place and the Tiffany Drive. That is
Oh,
basically,
really?
yeah.
Okay,
Because
thank you.
this one is a little flat, lower, and both the other properties are in a higher
Okay.
grading.
Does he, excuse me, Tony Hajar, does the applicant
Yeah.
have a copy of your reports?
I believe he does, yes.
So my question very simply is,
Yeah.
have you read it? Has the applicant read it? And is he in agreement with the points you make?
Are you gonna comply with all the items?
Yes, definitely. I had a chat with Jeff on that to clarify some of them, and I complied with this bullet points.
You're in agreement with all of the things he raised in his report.
Yes.
Okay. John, that solves the problem.
Anybody?
That's the case.
Yeah. Anybody else have any questions of Mr. Caliparico?
Just one comment I want to make. The fourth bullet, I was talking to Jeff. It was not a large stone. It was a rock, this size rock. And I couldn't move that, so I put it on the catch basin, but I will definitely remove it.
Okay. Any more questions of any of the board experts before we close the deliberation?
My only question is, if the board's going to grant it, you want to do it with C1 hardship, meaning it will create stormwater problems.
Correct.
And not a C2, I would suggest.
Right.
All right. Why don't-
Specifically with.
You can't, you got to turn that thing on.
Specifically.
Take this.
You guys are killing me.
Comment number 2, it talks about the landscaping. Are you willing to
He said yes to everything.
provide a
Yeah,
preliminary
so,
plan before the zoning permit?
so it's basically because I'm also doing a C2 variance for the 2-story building and the rain garden. So once I complete everything, the property will be landscaped actually, so that you can.
He's asking for.
He's looking for trees to screen the shed.
Right.
He's looking for trees to screen the shed. And he's saying, yeah, you say, yeah, I'll agree to provide additional landscape screening,
Number 2.
but number 2, but what.
John, Jackie's not gonna be able to get you. Tony and Jeff
John,
need to use the
microphone.
handheld
Rex,
mics.
I can't hear you.
Just turn them on. It's because you're not using them.
What Jeff is saying is he understands you agree with number 2, which says provide additional landscape screening from lot 25 and lot 27. What Jeff says is he wants the condition to not only say that, but that you submit a landscape plan for exactly what you're going to do before the zoning permit's issued for this, to leave the shed there. He doesn't want it loosey-goosey, in other words.
No, I
He
think,
wants to nail it down. That's what he's asking.
yeah, because I'm doing a construction, major construction actually, with the previous
Right.
resolution that was passed.
Right.
So there will be landscaping done and things like that. So I want to combine everything and complete it, not do a piecemeal.
Okay. I get it, but just remind me, I know this is, the other, what did the other resolution say, if anything, about landscaping?
You didn't say
There's
anything.
nothing in there about landscaping. Okay? We know that you are saying you're gonna landscape it. What Jeff wants is a condition saying, not simply you could landscaping it however you want to landscape it. Jeff is saying he wants a condition in there saying you will submit a proposed landscape plan. He doesn't care what you landscape for the rest of your project. He wants to see a plan showing what you propose to do with landscaping to screen lot 25 and lot 27.
Okay.
Okay?
Okay.
All right, so we're gonna add that.
Want to close for deliberation?
No, I think we got questions. I don't know those people.
Any members of the public here?
Yeah, any members of the public? Any of these still on?
There's one listed, but he's on mute.
Thing.
He's on mute. You put him on mute or?
No.
He's put himself on mute?
Yeah, I don't know if he's there.
Okay. We tried.
Do we know if he was here for the first application or?
No. he's-
Yes,
Second.
he's been here all night.
Okay.
Yeah, he was here on the application that didn't get heard tonight.
Okay,
My
fine.
guess is he just wants to see how the board operates.
Right.
He probably lives in this neighborhood.
Also possible.
All right. Want to close for deliberation? Who wants to start?
I have no issues with this. I think it's important that you set up, that setup that he has for stormwater drainage, I think.
A little louder? It's important.
I think I have no issues with this, with approving this application. I think it's more important that the stormwater situation is resolved and stays intact.
Kevin?
Yeah,
Randy?
just a a couple points, I did visit up by the property, and it's kind of like a downgrade situation where the property to the rear 25 and 27 are up.
Oh,
Elevation is higher, so there's a natural, I guess, topography there to deal with. And
That's correct.
The-
And his property is flat.
yeah, the
so
position of
water
the
comes
shed
down
and the gradient and the water has to be diverted, so it's not creating any issues with the shed. And I would agree with the position of it. It's a natural point to maintain.
Steve or Jim? Brad?
Nothing for me to add.
I would agree with what Cynthia had to say, as long as Mr. Kalapurakal is willing to go along with Tony's requests, number 2, 3, 4, and 5. I have no problems with this whatsoever. Someone would like to make a
Roger,
motion? Oh, sorry,
Jim
Steve.
Ferraro, I have no problem. That's why I was asking about him agreeing to the things the points Tony brought up. As long as he works with Tony, this is going to turn out to be a wonderful project.
I see the gentleman has come back on the screen again. Is he still?
Yeah, he's showing up.
If he wants to speak, I'm sure he'll let
Yep.
us know.
Okay. Sir, do you have something to say about this application?
No. Okay.
I think he's just observing.
Okay.
Steve, did you have
Steve?
something?
Yeah, I was just gonna say, I have no issue with the application. I agree with what everyone said, and I really feel like this coverage issue and these other issues that keep popping up, it's become like almost every application, it's the same issue. And I know that the ordinance was changed but man, some of these things are, and I understand that, and I know from my personal experience now that there's certain things that other towns do that are different than what we do. It's not universal throughout the state. I get that, but some of these issues are just so that they seem like they're really issues that we should be fighting over. But it is what it is. So I agree with everything that was said. I don't have any issue with the application.
Let me just make one suggestion that has nothing to do with this application, but the annual report that you guys do, right? Two theories behind the annual report. One is you report to let everyone know what's been happening, but you make recommendations. So if all these applications are coming in, maybe the board feels that the 40% shouldn't have been reduced to 20%. Maybe you make a recommendation that the governing body increase it, if not to 40, at least to 30 or something, but that's up to the board. But that's something that you can do when you get a flood of one type of application. Now, maybe you guys think, no, it should be 20, because you want to discourage people from doing that. And this is a sure way of discouraging them, because it costs a lot of money to get these variances. But that's the only thing I'm going to say, not having to do with this application.
The other thing is
Well,
we can't just
good
change
point.
Toll Brothers. We have to change the entire township
Right.
Yeah.
to go to.
Oh, yeah.
Well,
That's another good
John,
point.
John,
Yeah.
if I may, I think I'm glad you just said what you did. I mean, I agree with exactly what you said. I do think that this township has to do something about this issue, because
Yep.
if you really look at the issue, and I've looked at a lot of these applications, and I've looked into the issue legally, but this going from 40 to 20 has really caused, I mean, if we go back and look at all the applications that have this issue, I guarantee you it is a lot. And I don't understand, they have these products out there. I heard a little bit into the other application with the permeable pavers. Like, those pavers should not count against the applicant. That I don't understand that at all. But
Well, again,
apparently
the
that's
town-
what we do.
Steve, the township ordinance talks in terms of hard surface coverage, not impervious coverage. That's something else the board could suggest be changed. But just Tony's point, just so you don't only hear my point. Tony's point is every single one of these hard surface applications, other than one, Every other single one is a toll house.
Well, wait a second. I mean, look,
I'm
as
not-
Tony,
that's
as
what-
Tony knows, I've talked to Tony on my own end. Because I'm gonna have this issue, I think. I don't know yet, but so my house is not a Toll Brothers house. There are plenty of houses out there that have this issue. And
Right, the bottom line is you guys need to talk about whether or not you want to bring this issue to the attention of the township committee in the report, and how you want to bring it up. Should it be impervious coverage and not hard surface coverage like most other municipalities have? Or should it
And
be
doesn't it-
20%? And not-
doesn't it make our professionals' lives like terrible? I mean, this has got to be an issue that I know Tony deals with this all the time, and Jeff, I mean, it's got to make their lives like, it just causes so much chaos.
Every time we deny a permit, it does cause problems, you know, so.
Wait a minute, why don't we vote on, John, we were in the middle of debating, getting ready to vote on this thing.
Yeah, Jim's saying, let's vote on this and debate
Yeah,
it later. That's what Jim says.
Yeah.
Agreed. I think, can I speak one? I'm also a part of the board in that community, and that, as Tony mentioned, 110 houses, 90% of them doesn't know this.
90% have what?
Doesn't know about this. Everyone thinks it's a 40% hard surface because that's what it's printed and given to them. So when I spoke to my friends and things like that, they say, oh, we don't know that actually. And they will have the problem when they apply for anything.
And that's a document from Toll Brothers?
Yes.
Yeah, that's not right.
Well, we're gonna have the same problem with Carriage Gate.
The same problem is with Carriage Gate.
Yeah.
Went from 60 to 40.
Correct.
That's the Schneibel application.
Yes, and we're gonna see more of those. So,
I denied three different zoning permit in that development in the past couple of months.
Can you guys vote?
Yeah, yeah.
Vote on him and then talk later.
Roger,
would somebody care to make a motion?
I'll make a motion to approve this application.
I second that motion. Subject to all the conditions.
Yeah, subject to
Amy?
all the conditions.
Jackie, that was Randy seconding the motion.
Yes. And subject to all of the conditions.
Miss Cynthia Schaefer,
Yes.
Mr. Roger Aaron's.
Yes.
Mr. Kevin Cool,
Yes.
Mr. Randy Block,
Yes.
Mr. Steve Farcio,
Yes.
Mr. Jim Ferrero,
yes,
Mr. Brad Perry.
Yes.
There you go.
Thank you.
Okay.
I appreciate it. It's a long night. Thank you.
Hopefully, we won't be seeing you again.
I'm willing to come back.
Spend the evening with us.
Good night.
You guys want to talk about
Yes.
this issue for an annual report?
Yes, how do we add to the annual report? Because we have three things.
The biggest problem is, do we want to raise to 40% everywhere in the township? We can't just pick.
Oh, we understand that, we understand that,
we
but
understand.
it should be reevaluated. If nothing else, if we're not gonna say a percentage, it should be
So,
reevaluated.
so maybe what you want to do in the annual report, you don't have to make a specific recommendation, but you could say that because you've had X number of these hard surface coverage cases, two issues have come up. One issue is, should the township ordinance be regulating hard surface coverage versus impervious coverage? And the second issue is, whichever is regulated, was the reduction from 40% to 20% and 60% to 40% appropriate? And that's, both of those should be reconsidered. Now, do we know why they did that?
I wasn't here. so-
That was a negotiation with Toll Brothers?
No, no, no.
No.
No, it's
Across
cross.
the town.
Yeah.
long time ago.
Right around the development, they wanted to.
Okay.
Roger,
Yeah.
Jim Ferraro. I have to leave the meeting.
Okay, Jim.
Thank you.
Say
Thank
good
you.
night,
Good night,
everyone.
Jim.
Good night.
The other
Careful.
thing the board should keep in mind is, are we being recorded?
Yes.
Yes.
The other thing that the board should keep in mind is, we've been getting a lot of rain and heavy rain and big storms and everything else. So if we just make it 40, we may have township-wide drainage issues.
Right.
Yeah, maybe I'll bring it up and remind everyone, we had several deaths
Oh,
due
yeah.
to flooding.
Yeah,
And I know
absolutely.
everyone remembers that, but I think this could help. The problem is to make it very difficult to have all of this hard surface coverage.
I mean, the Benedict application, besides what he has, he wants another 1,700 square foot of patio. That's a lot.
Yeah.
The total is 3,400. That's as big as my house.
Yeah, his house is 3,400.
Yeah.
Yeah, so he wants outdoor.
That's why we made that comment.
Can I make a suggestion? Am I allowed to do that? Maybe instead of changing the impervious surface coverage, you just rezone Toll to a zone that has 40% coverage.
That's spot zone,
Yeah.
right?
You
Yeah,
can't
that's-
change the zone?
Well, you can if it's in conformance with a, the master plan, something coming from the planning board. If you just pick out one, that's gonna be spot zoning. Okay, so
Even though they're massively undersized for that zone?
Well, put it this way, what about carriage gate?
Yeah, we got the same
That's already a
problem.
R6 LM.
I understand, but that could be seen as unequal treatment.
Yeah.
Yep.
Yeah, we'll end up in court with that.
No, you can't do that.
So are we saying that we want to, just ask whoever makes these decisions to reevaluate it? Or are we saying that we want to suggest?
Well, what I would recommend is,
Go ahead.
this doesn't work. What I would recommend is basically to make a recommendation to the township committee to adopt, along with increasing the impervious coverage to whatever the board wants to do, to adopt like maybe a grading plan, and the applicant would have to apply for a grading plan, including stormwater. So if they disturb more than X square feet, or they increase the coverage more than 300, 400 square feet, they would have to do some stormwater. And this way, they don't have to come back to the board. All of that will be administrative.
There has to be some type of compromise, because this is a problem. I know a lot of other people who have this issue, and the applications, I'd love to know how many applications have been filed in the last year on this issue.
You're talking about zoning permit applications, not BOA applications, or both.
I'm talking about both. I'd love to
Because-
know,
Right,
yeah.
But because where are we on the annual report? Right,
Just started.
I think I
correct.
do that usually in April or May.
So maybe we start earlier. Amy generally, right, she puts together a list of all the applications that the board
yeah.
has heard and decided in the prior year. And then the board also makes any recommendations. But maybe you could also not just do the applications that have been decided, but specifically with this specific issue, also list the applications that haven't been decided yet that are seeking hard surface coverage variances. And then you can ask Tony how. Right, and just do a search.
You mean you want the ones listed that haven't come to the board yet, but
Right,
they're in our
that's what
office?
Steve is saying, just to see how many more are lurking out there.
I don't think we have any.
And again, though, you could find out how many more zoning permits you've denied that they have not applied for variances or haven't applied yet. And then if the board is not unanimous as to what to do about it, then at least just bring it to the attention. I bet you the township committee has no idea.
Yeah, and there's got to be somebody that was an expert that the reason they did this. I don't feel comfortable making a recommendation to a certain percentage because I'm not an expert. If we said 30% and then all of a sudden we're still getting all these variances,
Right.
I would like somebody that there was a reason they did this. Why did they do it? And could they reevaluate it? And here is the evidence that we're showing you
2006.
through either.
Yeah, the person who's gonna know is James Humphreys. He was the planner in 2006. He now he works at the Highlands Council, which in the Highlands Council is into stormwater. James would probably know. I speak to him occasionally because I have a bunch of Highlands communities. I can ask him, but my suggestion is just bring it to the attention in the annual report that you're getting all these applications, and I'm suggesting that they look at two things. Should they be regulating hard surface versus impervious without taking a position on it? And what is the correct, what's the appropriate, not correct, what's the appropriate percentage? They might come back and say the appropriate percentage is just how we have it, and they might come back and say, and we want hard surface because of this, not impervious, or they might say, well, the hard surface is a carryover. Yeah, maybe we should switch it to impervious, but we want to leave the percentages as is. But I'll bet you anything that they have no idea
Right.
how many applications.
Well, if we
come
put in
through.
the third recommendation I would like is that if we have too many applications, that we have a
Oh, the
fall
supplemental
over
board.
to the planning board. I like that I'd like that recommendation in there
It's not to
too.
the planning board, the supplemental board
So-
to be made up of
Planning board,
members.
yeah.
If you guys just want to email me your ideas whenever, I'll just put them in a file, and then when I work on my report, I'll just incorporate them.
Okay.
And then it's going to go on one of the agendas in the spring. You guys can just review everything at the meeting before we approve it.
Okay.
Okay, Amy, next meeting, we have, which ones again?
That is ESCO. I just passed out
Yep.
to you guys. They resubmitted their materials, so that's what you guys got tonight.
Okay. Anything else? Motion to
Oh,
adjourn?
I have one question. I don't
Oh.
know if we want to bring it up. We're staying in person, or what's the general
Yeah,
consensus
good
for?
question.
That's a good question.
Because I know we do have some applicants that have to notice for their February and March meetings. I've kind of been advising them to hold off as long as they can in case anything changes.
My suggestion is until and unless the curve comes back down, that you go back. I know that you leave an option for people who want to show up, to show up. But people who don't, and if an applicant doesn't, you let them all have the option. You keep the Zoom open like it is now, but as long as do you have any board members who are absolutely willing to show up?
Yeah,
Okay, so at least you have one.
I can sit here by myself. I'm
Right.
Yeah, no,
So-
I'll show up too.
So as long as you have one board member in the room, in my opinion, you have an in-person meeting, and you allow a Zoom option. So
Is
the
the
no-
Zoom option just for board members at this time?
Well, no, at this point, I would suggest
Yeah.
you give the Zoom option also to applicants until the curve starts coming down.
Applicants and public and everybody.
Yeah,
I'll-
just not the applicant's attorney. They had to show up. No, I'm not kidding. No.
So I'll put it back on the agenda like we used to do.
Yeah. So
Okay, I was
in-
gonna say, because the next several meetings are people that we're carrying, so I don't know how that would work with, they already noticed for in-person, we're carrying them to
well,
in-person.
hold. We are holding in-person meetings.
Yeah,
We're offering a Zoom option for anyone who wants to partake.
okay.
Randy, do you want to keep coming?
Well, I live so far away, I might be able to do that.
All right.
Depending on the application, if it's a couple of these Cs, I might Zoom it, but for these big ones, I'm gonna show up
Yeah.
because it's much easier to talk to board members
Right.
and to, talk to the professionals if you're here. You guys are gonna be here, right?
And if you're on Zoom, then Tony can have your microphone.
Microphone doesn't work. Wait a minute, so moved. Anybody want a second? Second. Thank you.
Adjourned.
Okay.
All in favor?
Aye. Listen, before we go, I just want to say,
Are we recording or no?
I just want to say thank you to Cynthia for her service
Yes.
last year. I think she did a hell of a job.
Comments came before I took over as chair, and I already had that speech planned, but thank you for doing that because I forgot.
You forgot. How
Yeah.
could you forget?
Cynthia, thank you.
Thank you.
Yeah.